This meeting of the Anderson Township Board of Zoning Appeals is hereby called to order. This board was established pursuant to Section 519.13 of the Ohio Revised Code by the Anderson Township trustees to provide administrative relief to any person or entity adversely affected by the Anderson Township zoning resolution. Will the secretary please call the roll?
Brian Ella.
Here.
Fred Hayes.
Aye.
Steve Faber.
Here.
Brian Johnson.
Here.
Rick Overschmidt.
Here. Thank you for coming to the meeting. This meeting is audio and video taped and may be carried live on local cable television. Our procedures, briefly, we have one public hearing today. A summary of the appeal is presented by the staff, then the appellant can present its case. We'll then ask questions of the appellant. Anybody supporting the appeal is permitted to testify. Anybody then opposed to the appeal is permitted to testify. Anybody wishing to testify may do so only after being sworn in. When testifying, come forward to the microphone, either one. State your name, address, and any affiliation to the case. All testimonies given to the board, and we'll hear only new, non-repetitive evidence or questions. Now, will all persons who may give testimony this evening please stand? If you will raise your right hand and swear or affirm, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Any changes to tonight's agenda?
No.
All right. I'd like to welcome a couple of our observers from Boy Scout Troop 170 in Hyde Park. Bring their government service badge in here.
Mr. Chairman, should we consider moving the one new case up in the agenda so that we can do the administrative things later?
That's fine. It's up to you guys.
Fine with me. I'm happy to do that.
All right.
Fine.
Okay. All right. Good. I'm sure you're happy to know that you can bump up. Okay. Consideration of case 12, 2013 BZA, submitted by Jeff Rose on behalf of the Archbishop of Cincinnati.
Let me get to that part of my PowerPoint. There we go. Yes, this is a property owned by the Archbishop of Cincinnati. It's located at 274 Summit. It is zoned both H Riverfront and A Residence. So this is appearing before us because the use of the property is a conditional use within the residential district. This was established in 2007 by the Board of Trustees. And their request is for a 24 by 24 foot pavilion to be located within the front yard area. So we're looking now at, we jumped backwards a little bit there. Sorry about that. So looking now at a location map of the property, the green is the H Riverfront zoning, and the A is the residential zoning. You can see to the south there is some E zoning, which is owned by Coney Island. To the west of this property, we do go into the city of Cincinnati's zoning. Some history about this site is that Altercrest offers residential mental health and educational services. It was established in 1976 at this site. Previous zoning certificates have included some additions in 1998, as well as a new institutional building in 2007, and this was done just prior to the establishment of the conditional use standards by the Board of Trustees. So we can see an aerial photo of the site, and I've marked the approximate location of the proposed structure. You can see that it's within this wooded area on the southwest portion of the site. Here's a proposed site plan. The structure will be 26 feet from the side property line and is proposed in this area as there's an existing drive and kind of clearing in this approximate location. I included a topographical map just to show you that it is on the top of a ridge there. The site has several hills throughout it, and it is kind of a rolling topography. The site has approximately 448 feet of frontage on Sutton, and this portion is over 29 acres. We've got some elevations of the proposed structure. So we look at both conditional use standards for this as well as variance standards. which we'll get to momentarily. We're going to see some property pictures here. You can see that it is fully screened in each direction. Conditional use standards look at the overall acreage of the site, which is, I'll put together approximately 40 acres, while the buildings only occupy 1.16 acres. The structure is located adjacent to retail zoning. No additional parking is being proposed, and no changes are being made to any access or the flow of traffic. We feel that the proposed structure is compatible with surrounding conditions, and that the mature vegetation will screen the proposed structure. No signage or lighting is being proposed at this time. The overall use of the facility will not be changed through this proposal, and methods currently in place to maintain contact with neighborhood residents will continue. The addition of a pavilion structure will not significantly change the intensity of use for the site or greatly modify the existing impervious surface ratio. The current location of the pavilion is adjacent to an already paved area. When looking at variance standards, staff felt that the granting of the variance will improve the experience of current and future attendees of Alta Crest, that the variance is not substantial. The pavilion will be fully screened from the view of adjacent properties and is approximately 585 feet from Sutton Road. The essential character of the neighborhood would not be substantially altered, and adjoining properties would not suffer a substantial detriment as a result of the variance. The pavilion will be located so as not to impact adjacent properties. The variance would not adversely affect delivery of government services. The property owner's predicament cannot be feasibly obviated through some method other than a variance. The proposed location of the pavilion is easily accessed by an existing driveway which opens to this flat area suitable for this type of development. And finally, the spirit and intent behind the zoning requirement will be observed and substantial justice done by granting the variance. The pavilion will have essentially no impact on surrounding uses and will not be visible from adjacent properties.
I have one preliminary question. Could you go back to the zoning map? It looks like is it adjacent to E-retail because the write-up didn't mention E-retail in the surrounding conditions?
It is adjacent to E-retail to the south. Coney Island owns, on this side of the road, a portion that is both H Riverfront and E-retail.
Okay, so it's both H Riverfront,
Yes.
but it's really E-retail that's immediately adjacent?
Yeah, the direct neighbor is.
Thank you.
Allison, to build on that question, the topography there is a steep slope.
Yes.
Is that likely to be used in any substantial retail?
No, more than likely not. The applicant can testify to an original conversation with Coney Island was that perhaps the structure would wind up located on that property, and Coney Island was comfortable with that. It worked out that it could be located on Alta Crest's property.
Yeah, this is on the applicant's property
Yes.
completely. Yeah. You show a building to the west of the general site there that I didn't see,
No, that is not there at this time.
and there's no proposed structure to put in there
No.
either. Okay. You had the address at 274 Summit, but it's really
Sutton.
274 Sutton,
Yes.
right? Okay.
Other questions of Allison? Can I just ask one more clarifying question? So when you look at this big 40-acre tract, whatever it is, the front yard is considered to be,
The front yard is considered to be, we can kind of see this structure here. Anything in front of that would be considered the front yard area.
well, they have a little 20-acre front yard.
A little bit.
Okay, great.
And the building out nearer the road that you would normally consider the front yard is a
An accessory structure.
accessory structure in the way that we see it, even though it was probably there even before the
Correct,
zoning
yeah.
resolution was passed. Okay. One other question, Allison. At the end of the write-up, there's a disclaimer paragraph that I had not seen before. Is that new?
No, we've been including those on all of our staff reports lately.
So it's me. Sorry about that.
That's really just to assure anyone that would come in and get a staff report that this is one piece of evidence. We also look at testimony and everything as well.
Yeah, I didn't see any harm in it. I just never read it before.
Any other questions about Allison? If not, would the applicant like to come forward and give us any further information or rehash any of the information we have?
Good evening. It's a fairly
Can
straightforward...
I get your name and
I'm
address?
sorry.
That's
My
all right.
name is Joseph Kassir. I'm Associate Executive Director with St. Joseph's Orphanage. We operate the facility down at Altercrest. And I'm coming before you now, but it's a fairly straightforward proposal. I just thought if there were any other questions that you may have regarding our request for a waiver, or variance, rather.
Could you tell us a little bit about Altercrest? I don't think a lot of people in the community, I know myself, are not real familiar with it. Is it residential? Is it, do the children come and go every day? Could you give us some background on the use, please?
Sure. Altercrest is a campus that provides mental health services and special educational services to youth and adolescents, primarily males, from the ages of 12 to up to 17, 18 years old. We operate a continuum of mental health services, meaning that the levels of services range from actual residential care where the boys live there to day programming where the boys live off grounds but come during the day for our group work and our education. And we also operate outpatient services, community-based services that use Altercrest as the primary office location.
I don't think this is in the materials, but one of our criteria is effect on government services. And from what I've seen, I don't think the pavilion has an effect on government services. But I do, in my job, I receive police run reports, including for here in Anderson.
Yes.
And that's actually how I became aware of it, because I noticed, I wonder what's going on Sutton. I see police runs down there. Can you tell me a little bit about why there are police runs? What
Sure.
is security? What will be security associated with these outdoor activities, et cetera?
Sure. The population that Altercrest provides services to are severely emotionally disturbed youth. Many of these boys have been involved with the law at some point in time. Mostly they get in trouble because of their behavior. We are classified as a staff-secure facility, meaning that we are not locked. Any child or any youth that requires that level of programming as a result of their behaviors generally will have to be either managed by the state in the correction system or in a locked psychiatric facility. So we are a step beneath that. In terms of the police runs, because we are not a locked facility and because we are not a medical facility like a psychiatric hospital, if we have incidents where some of the boys are having a rough day, particularly if, for example, we have, it's very common for some of the boys coming in from the community because they have impoverished community settings that they're coming from to not take their appropriate medication. And as much as we try to maintain an ongoing relationship with the parent or the home, sometimes those kinds of things don't happen, or for whatever reason, a kid may come to us during the day, have a bad day. Now, in a psychiatric setting like a hospital, if a kid or any individual starts to become aggressive or out of control, they can use either chemical restraints, medication, or mechanical restraints. They can strap them down. Now, the level that our kids are displaying generally, again, is one level below that. But because of our licensure and our programming, we don't use any type of mechanical or chemical restraint. We are qualified and trained to provide physical restraint, hands-on, if a child is exhibiting an imminent threat of danger to themselves or others. But if a boy decides he's going to create mischief, run around, and generally come up to the edge of behavior that would be considered, definitely disruptive, but not move over into that risky type of behavior, legally, we can't physically intervene with that child. Sometimes we're successful in de-escalating those situations, sometimes we're not. And when we're not, we intervene. If the interventions are successful, then everything's good. Occasionally, things might reach the point where the risk to the child, the other kids, and to the staff warrants us to contact the sheriffs. And that's why you would see a lot of runs down the Alta Crest. It's
Okay.
really the nature of the business.
And with the outdoor pavilion,
Yes.
which looks like a nice structure, is that going to create an environment of there might not be as much control or anything, or will that have no effect whatsoever?
On any given day, we have anywhere from 50 to 60 boys on grounds. And on any given day, I've got probably 2 or 3 that are being foolish. For the most part, the behavior of the boys is really very positive. Generally, when we have activities, we use them as rewards. Kids earn the right to either go off grounds on field trips, take part in other types of activities. So for the most part, the security issue for us, for the boys in that area, is really not going to be an issue for us. If a kid is having a really bad day and the rest of the group's going to the pavilion, we're going to encourage that kid, can you get in line with what's going on here, take part of what's happening here. But if there was any incidents that occurred out there, again, we are staff secure, so we would have enough staff on grounds to maintain that child and probably escort them back to the facility if it was an event for the rest of the event.
Okay, thanks.
Thank you. Any other questions? Fred?
Yeah, I had a couple of questions. You said that Coney Island did not hesitate to support the efforts. What kind of support is Coney Island offering?
Jeff Rosa actually had that conversation, and initially, when he pulled up the map on the system, we thought the property line was much further up the hill than it was. So when we first started looking at this project, we thought, we're basically halfway over Coney's property line. So it wasn't until I was able to obtain some old drawings that we realized that was an error. But until that time, Jeff had taken it on his own to contact Coney Island and explain what we were doing and ask them if they would have any problems with us erecting this pavilion, even if though it would possibly be partially on their property.
So they're not going to financially support it, but they were very supportive of permitting you to put it on their property.
Correct,
I
correct.
understand. The slope of the property right from the positioning of the pavilion off to the south there is, I won't say
Severe.
dangerous, but it's scary.
Severe, yeah.
Yeah.
Can be.
Are there going to be any issues that way? Are you going to erect a fence there to make sure that that boys roughhousing a little bit don't end up at the bottom of the cliff?
Well, first of all, we don't allow the boys to roughhouse. So boys starting to get into it right away, that gets managed. To address the issue of safety regarding the slope, that particular area, and you can kind of see it in that topo that's on the screen now, the dark green areas represent the more steeper areas, and we are a bit away from that. Now, I've actually hiked all that property many days when, particularly if it's a bad day, I'll go out walking in the woods. That area up there is actually not very bad. You can actually walk down the Sutton Road, and it's a little bit steep, but you can actually do it. Whereas if you move further east, that's impossible, particularly right directly across from where they're building the new casino, where a previous owner had mined some of the material out of the hillside. I do have a fence up in that area. The fences sometimes become challenges for the boys. So, we're very mindful of what kinds of things we put up in it around that facility so that it doesn't attract the boys unnecessarily. So we are mindful of
Okay, thank you.
that.
I just wanted to follow something that Fred said, because I thought you said this was going on Coney property?
Well, the original thought was that it was going to be on Coney property.
Okay.
But when they got out the accurate maps, the structure is
Just
on,
totally on Alter Crest.
totally on
Okay.
the applicant's
Right.
property.
Okay.
Yep.
I'm good, thank you.
Ryan, any questions?
My question's on security and fencing, you already covered, so I'm okay.
Is that it?
Thank you very
All right,
much.
thank you all.
Anybody else care to testify about this case? You guys are passing? All right. We'll close the public hearing on case 12, 2013, BZA. Do we want to go ahead and deliberate on that right now while we've got it right in front of us? Is that all right with everybody? Change the agenda? All right. Entertain any discussion on this application?
Well, I did appreciate the history on the facility and how it got there. It was interesting for me to go back and see it. I'd never been back there before. It was an impressive facility, and they have challenges there. They do the best they can. I don't see this pavilion necessarily changing that. It was interesting for me to hear the history, and it looks like this would be a nice amenity for them to have, and in reviewing the staff report, it appears to meet the criteria. Thank you.
Yeah, I completely agree with Mr. Ellis' conclusions here. I would add one restriction on granting the conditional use and the variance here, is that the road up to the pavilion should be cleaned up and provide better access to it in case the police or anybody else needs to get up there quickly. That's a rough road to go find and to get up there. The underbrush is growing over the road.
Steve or Brian, any thoughts or
I
comments?
echo everything that's already been said. I'm in agreement.
You know, in my view is when you're looking at this size of a tract, I mean, the front yard requirement is a little absurd, and then with the unique topography of this site, very limited.
Right.
Anything else, Brian?
I took a tour yesterday. I would agree with the one requirement of cutting the overgrowth back. It was kind of tight getting up there, but I'm in agreement with the staff opinion.
All right. Entertain a motion on this? Who wants to turn at it?
Yeah, I'll try and do it. In case number 12, 2013 BZA 274 Sutton Road, I move that the board approve the request for conditional use per sections 357 and 358, as well as the variance request to allow the detached accessory structure in the front yard where it's required to be located in the rear yard per section 171.7, and I would add the following findings and conditions that with regard to the conditional use, that the criteria A of section 357 requires a minimum of 5 acres. The site contains almost 40 acres, and buildings occupy 1.16 acres, so there's the anticipated space requirement is well met. The proposed structure is located near retail zoning, and therefore the setbacks from any adjacent residential property line well exceed the minimum 50 feet for buildings and 25 feet for parking areas. Criteria F, that parking shall not be in an area defined as a front yard. That's not applicable, as there is no parking being proposed. Criteria G, there is no change to the access regarding onto a collector street. Criteria H, there's being no changes to the vehicular access areas. Criteria I, again, no changes to traffic flow. Criteria K, again, no changes to the access. With regard to criteria M, alterations to an existing structure shall be made that do not depart from the residential character, and that the structure shall be compatible. We heard evidence and have seen that the proposed structure is compatible with the surrounding uses and is designed to fit in with the scenic woods and steep topography in the area, as well as being compatible, again, with surrounding conditions with regard to criteria in the architectural design and site layout. With regard to criteria O2, there being sufficient buffers and landscaping, we have seen through the photographs presented and site visits that there's extensive mature vegetation surrounding the proposed structure. In fact, it will largely not be noticed to the casual passerby. Criteria P1, no signage is being proposed, and that also applies to P3, so those are not applicable. Criteria S is not applicable regarding lighting. There are not being any changes, as we discussed, to the main facility and proposed general use, so that will not be applicable with regard to construction of the pavilion. And with regard to maintaining contact with neighborhood residents, the information provided is that there is currently a method in place, and that will continue to apply. And finally, criteria Y, the intensity of the particular use shall be evaluated with regard to location, size, and configuration of the track. The pavilion will not significantly change the intensity of use of the site or existing impervious ratios, and the proposed location for the pavilion is adjacent to a currently paved area, and also the testimony we heard is that this is a very large and wooded tract, and this will fit nicely in that. So the grounds for the conditional use are well-founded in this case. With regard to the variance, we would find that granting the variance will improve let me see, do we have the variance criteria listed here somewhere?
I'll put those up on
I
the
see
screen
the
for you.
conclusions of the staff, but
Hold on a second, they'll bring it up. There we go.
thank you. Okay. With regard to the property in question yielding a reasonable return and beneficial use of the property, we find that the granting of the variance will improve the experience of the current and future attendees of Altercrest, and as we heard the testimony, this will fit in nicely with their structure where they use these types of facilities as a benefit and incentive for their residents and students to excel. The variance, is the variance substantial? We find that it is not substantial. The pavilion will be fully screened from the view of adjacent properties and roads. It is 585 feet from Sutton Road. We have heard evidence of the unique topography of the area, and also the comment and observation of the board that this is a very large front yard area, and so the usual thought of restrictions on the front yard area basically are not really applicable in this case. The essential character of the neighborhood would not be substantially altered. As we heard, the facility is already there, it's already operating, and this is simply an addition to make it a better experience for their students and the overall facility. The variance would not adversely affect the delivery of government services, and we did have some discussion on the police. The evidence is satisfactory that there is means in place to control any adverse activity to the extent allowable under their permit, and that they are very aware of the need to not create conditions requiring additional government services. Property owner predicament cannot really be feasibly obviated through some other method, as the testimony indicated that this is an amenity for the already existing use, and we find that the spirit intent behind the zoning requirements would certainly be met and substantial justice done by granting this variance. The pavilion will have essentially no impact on surrounding uses and will not be visible. And we would like to also offer, I'd like to offer one condition, and if the board has any others they'd like to offer, that we have found that the access to the pavilion area is difficult. And we've also heard that there is sometimes need for emergency services there, and also that there is some fairly extreme topography nearby which may someday require a need for services. So the condition would be that the access road be improved to the extent that it's easily passable by at least a regular police car type vehicle. And also that the proposed pavilion be built in conformance with the site plan and plans that are stamped dated received May 20th, 2013, that construction be begun within 1 year of this evening and completed within 2.
I have a
Second.
motion. I have a motion and a second. Any further discussion on the motion?
Well done.
Unbelievably well done.
Wouldn't change a word. Molly, we have a motion and a second. Could you call roll, please?
Ryan Miller.
Aye.
Fred Hayes.
Aye.
Steve Haber.
Aye.
Brian Johnson.
Aye.
Rick Oberschmidt.
Aye. Okay. Good luck with all your efforts.
Thank you.
down there. Okay, approval of minutes. I believe that Fred and maybe a few others have provided some comments to staff on the minutes, which
Yes,
have been
those have been
incorporated.
made.
Okay,
And if I could find my minutes, I did not see the other comments, but I just noticed in one, you give me 2 seconds, I'll find it here. Yeah, did you, on page 2, Mr. Johnson's remarks, it says stayed, I think the wording was abstained.
Stayed.
Did we get those changes already? Abstained?
Yes,
due
now
to-
it says, Mr. Johnson stated that due to knowing Mr. Uhlenbrock, he will abstain from this case.
Thank you, okay.
That's it.
That's all I had, yeah.
Mr. Chairman, I move that we approve the minutes of the May 9th BZA Township meeting as amended.
Second.
all in favor?
Aye.
Abstain.
Aye.
Okay, next case, 6/2013 BZA. This is a case, Beachshire Drive, the chicken coop case that we heard last month and took a straw vote on it, and asked for the written resolution to be typed up so that we could consider a final vote on it this evening. And I believe that was in your package. Does anybody have any questions or comments? Mr. Eliff may have the same one that I do.
Yeah, I did notice, and I think we maybe need to add a little more emphasis on the remark, paragraph 2, number 2 of the draft, that the variance is substantial due to the testimony presented. I believe the only person that testified was the applicant, so really, I think there were remarks from the board regarding the unique and small shape of the lot, that it was surrounded on multiple sides by residents, that the actual distance was substantial, although maybe that's talked about at the end there. Yes, it is significantly reduced, and so I believe there are some factors that we made in our observations and discussion that would fit in there a little better.
Yes, I was going to suggest that I was going to say lot size and relative location.
Yes, that's perfect summary, yeah.
Lot size and relative location.
Uh-huh.
You going to bring that up on the screen and make the changes as we've done in the past, or,
Not for this one, no, since they were in the packet.
okay? So you're going to you're going to make the changes and then reprint it?
That was the only
That was the only
comment I
change I
had.
had.
Yep.
Any other changes? I'd like to entertain a motion, though, to approve it with that change.
Okay, I'll make a motion that we, I guess we're going to approve this as,
We're gonna-
As amended.
approve the, okay. Okay, I'll make the motion in case 6-2013 BZA that we approve the resolution as amended, which denies the request
Journalize that, too.
and journalize. Thank you.
Second.
Molly, we have a motion and a second to, on the decision in case 6-2013.
Brian Ella,
Aye.
Fred Hayes,
Aye.
Steve Haber,
Abstain.
Brian Johnson,
Abstain?
Rick Oberschmidt.
Aye. Okay. Next is decision and journalization in case 8-2013 BZA Puppywood Pet Resort. The decision on the exterior fenced area near a residential zoning district.
Mr. Chairman, I think the resolution is very well drawn up with two exceptions that I would propose that we make. We need to have a space in front of, in the first paragraph, between the distance of and 200 feet.
Got it?
And secondly, in the middle of the second paragraph, there can be a beneficial use of the property as a residence. It should be the beneficial use of the property as an internal animal care business. Those two changes, I had no further changes.
I agree with those.
Got that? All right, I'll entertain a motion on this one as well.
Mr. Chairman, in the case 8-2013 BZA, the DRB Consultants 2 Limited, I move that this board approve the resolution to deny this variance with the journalization amended as previously discussed.
A motion, do I have a second on that?
Second?
Any further discussion? Molly, could you?
Brian Ella,
Aye.
Fred Hayes,
Aye.
Steve Haber,
Abstain.
Brian Johnson,
Aye.
Rick Oberschmidt.
Aye. All right, next up, consideration and deliberation on case 10-2013 BZA. That is the case that we held the public hearing last month, closed the public hearing, but asked for more information about proposed landscaping. Any further
No,
comments
I
to us?
included the landscape plan in your packets, and then have it up on the screen as well. The applicant is proposing to add an additional 6 evergreen trees to the existing landscaping that they currently have.
Okay, and now for clarification on this case, Steve, are you going to participate, or are you going to abstain? Do you
I'll
feel-
probably abstain.
Okay. All right.
So,
And Mr. Johnson is already abstaining as well, so it's the
Are you out
three
of this
us.
case? No.
oh, that was the other one.
That was the other
It was
case.
the other one? Okay, sorry.
He's in this one. I'll ask this,
So I guess the question is, that it's now time to deliberate this case.
can I ask a staff question?
Sure.
So by them presenting us this landscape plan, it shows 6 new trees, but it also shows the existing landscaping. So if we approve it with this condition, it would be everything that's there,
Everything
correct?
that's there, yep.
Okay. Thank you.
And another question for staff. On the landscape plan, it does show the plan view. It does not show the elevation view.
Correct.
And part of the testimony concern that we heard in this case last month was the view from the street, and especially from the neighbors across the street. And part of the counter testimony was that the level of the pool and the level of the patio would be well below the level of the street.
Correct.
And so probably would not be visible. I can't tell that from this plan, though. Am I missing something? Or what's your judgment as far as visibility from the street? And
Well,
from
the
across the
applicant
street?
does state that they're proposing 6 4-foot evergreen trees to be staggered in this area.
Do you have an aerial photo showing, yeah, there you go.
Not
So,
quite zoomed in.
I can't remember which, one, I believe the
It was the
owner.
property at 2206, this home that
2206,
submitted the
okay.
letter.
Yes.
Okay.
And this sits down below it,
Yes.
below the street. But I guess if you're up on their second floor, you're probably looking over it all.
Second floor I'm less concerned about. I was really concerned about the first floor.
Did they, let's see, how tall are they?
4 feet.
4-foot trees.
Oh,
I mean, to start, that's,
The trees out along the street actually are higher
Yes.
than that and provide further, higher level screening.
Well, it looks like the bulk of those additional evergreens would be right in front of the 22, can't read that, 06, is it?
yes.
Yes.
Front of 2206.
And they are positioned to properly screen the pool.
Yes, they are
in large-
staggered.
In large part. Yeah.
Any other questions, or do we want to start having a little discussion about what we see the merits of this? I believe the other major concern raised the last time dealt with drainage issues a little more downstream, and trying to assure that this project did not exacerbate an already bad situation.
That was part of the testimony, yes. Although it was part of the concern of that individual. I think as we discussed as that testimony was being presented, that the pool would actually slow up the runoff and decrease the drainage in the downstream creek.
I believe that's what the construction, the pool fellow was saying, that there'll be, because there's some area in the pool that can retain some water.
Yes.
Right. I don't, as opposed to probably what could be built there as of right, I don't think the pool is going to have a significant impact. I know we didn't have expert testimony on it, but it's just not going to create a lot of impervious surface that couldn't be there anyway. And then secondly, even though they have some backyard there, there was pretty solid evidence that it's not going to work there because of the topography, and there's a easement back there for some type of pipe. And, you know, another thing that makes me comfortable with the landscaping is it's not unheard of, but it's a little unusual when the owner comes with the HOA. So they have an active HOA in that subdivision. It sounds like they're very active and they're engaged with what's going on. So I think that presence, in addition to our landscaping plan, would in addition to the physical limitations of property, give me a pretty good comfort level that this would be a variance that'd be well taken by the board.
I agree.
Ron, your thoughts?
I understand their predicament and not be able to put it in the backyard, but I'm sympathetic to the neighbor across the street and what he's going to be looking at, and has been stated, we can't really determine from the drawing submitted how that's going to block his view. So
I'm a little closer to where you are. I mean, I think that there are some lots for which just weren't made for swimming pools.
yeah.
And I have a concern about a pool, you know, that's in the side yard and almost partially in the front yard almost, that's really visible from the other houses. I don't think that's what people bargain for when they buy across from it. On the other hand, obviously, there's a benefit to, even if they tried to wedge it in where they could as a matter of right, that would result in destroying a lot of the natural vegetation. And we certainly had testimony from the people who are frankly the most affected, the immediate neighbors, supporting the project. So I'm very, very torn by this one. I just can't get over the concept of pools that close on the side up to, close to the street. But I'm not,
I know some of this landscaping would deafen the noise that goes along with the pool, but if you were one of these houses that's in your front yard, would you, is that something you would expect to happen when you buy that house?
Well, I heard the pool comment too, and that rang true with me where my house is. At one time, I had 3 pools, not quite on the corner, I had 3 pools around it, 2 on each side and then behind. And then one fellow filled his in. But the pools can generate some noise, but is it the kind of noise that's not expected in a residential neighborhood? Do kids out back playing on the trampoline generate noise? Do kids, Yeah, yes, they do. So I was sympathetic to the question noise, but I didn't think this was an unreasonable noise that I would say I would hold as a reason not to grant the variance.
Do you think it would detrimentally affect the resale value of the house across the street or one of those?
I don't think it would, but I just know from, I think I commented at the last meeting, I went out and looked at it, and it was very nicely done. And the landscape plan adds some guarantee, although not a perfect guarantee, that would continue.
Well, we could put a restriction in there to continue the maintenance of the landscape,
Yes.
so that if it grew to be too big and not fulfilling its function, we could say that the enforcement of this certificate says it's got to be maintained, it's got to be changed out to fulfill its screening function.
In my mind, when we look at the standards, it really comes down to standard number 3, and trying to make a decision on it. This is not going to impact government services. The property owner can't really feasibly obviate the condition. But I do think that it comes down to how whether we think this is altering the character of the neighborhood and whether the adjoining property suffers a substantial detriment.
That's a good summary. And the other 2 adjoining properties gave testimony that it was not a substantial change for them at all. It's the lone property owner across the street that has the concerns. And I think the landscaping plan, while I have some concerns about the elevation aspects of it, I think the landscaping plan does provide the needed screening to protect that property owner.
Any further thoughts, Brian?
Not for me.
I don't know if it would help or hurt, much like when we hear chicken cases, it's the location of an accessory structure rather than the use.
In this case, the accessory structure, so to speak, is all in the side yard, not in the front.
Right.
Okay.
Well, it's a good example of, we do, although I'm in favor of it, we do hear a lot of kind of corner cases. I guess this isn't truly a corner case, though, is it? But we grant them, but this is a good example of where it's a little different, because it is common for this board to issue those kinds of things, but we do have a little bit of a different situation here. But I think that the landscaping plan handles that.
Well, I think at this stage, I'd ask, Brian or Fred to make a motion, and then we'll call the question. And if we're able to get 3 votes one way or the other, then we're able to resolve it. If we're still at 2 votes, then we have a rehearing. And I don't think we've got the ability, well, the only other thing whether we have the ability to adjourn this case, let Mr. Haber review the tapes, and come back with a 5th vote, but I don't know if that's...
Our motion might be so persuasive, though, that...
It might be. It might be. I don't want to presume how anybody...
I was going to take a
this-
shot at that motion now. I'm
Yeah,
not so
okay,
sure.
a little pressure on you.
I guess we can deal
Maybe
with...
even Mr. Johnson, we don't know that.
I'm putting the
right
cart before the horse, so let's but maybe we'll entertain a motion from one or the two of you.
Mr. Chairman, I move that this board, in the case number 10-2013 BZA 2209 Endo Valley, approve the requested variance with the condition that the plans submitted dated April 19th and the landscaping plan dated May 22nd be substantially complied with and maintained in the future indefinitely. We find that the property in question will yield a reasonable return. The variance is significant, but is not substantial enough to essentially change the essential character of the neighborhood, in that the neighborhood would continue to be a single-family residence, and comfortably. The variance would not adversely affect the delivery of the governmental services. The property owner's predicament cannot be feasibly obviated through some other method, such as locating the pool, the structure in the backyard. We heard testimony that it would be infeasible. So the spirit and intent behind the zoning requirement would be observed and substantial justice done by granting the variance. I would further stipulate that the construction begin within 1 year of today's date and completed within 2 years.
Second?
Motion is second. Any further discussion? Did we refer to the specific plans?
Yes.
Yes.
Yeah, okay, we got the
Both
specific
both
plans.
sets of plans, the April 19th plans
And
and
the
the May
land.
22nd plan.
Okay.
I'd just say on further discussion, I commend Mr. Hayes for that motion. And, you know, when we talk about what this board looks at as hardship, and we try to capture the essence of what hardship is through these criteria that have been laid out for us through precedent. But if you just kind of look at the bigger picture of this property, because of that easement that's in the backyard, and also the topo in the backyard, and the stream that's back there, they're largely without an option if they're going to put a pool in, and it is common in single-family neighborhoods in Anderson to have swimming pools. And so I think, you know, when I look for hardship, and there's definitely some physical hardships here that prevent it going in the backyard.
Any further discussion? Molly, would you like to?
Brian Miller,
Aye.
Fred Hayes,
Aye.
Steve Haber,
Abstain?
Brian Johnson,
Nay.
Rick Oberschmidt.
Aye. It's a good argument, Brian. I was persuaded.
Thank you.
Good.
Okay.
We can take a break while I draft
That
those
language.
resolutions and then look over them to journalize them, and
Let's
then,
take a brief recess while we, that's just that, yeah, the two resolutions. Thank you.
comma after 2000?
We'll come back in session to consider the formal resolution, case 10, 2013 BZA.
In that first line, I think as Mr. Johnson was starting to say, the comma after 2013 should be moved to the second 2013. Yes.
Is it a singular variance or multiple variances?
Singular.
To grant a variance, then? To grant a variance.
Mhm.
On number one there, detriment, just had the E and the I switched around there. Yep.
Probably, the line below that, it's probably a period after variance requested.
And an additional sentence, I think, at the end of number one there should be the landscaping plan submitted as part of this record will reduce the effect on the home across the street to the east.
I don't know if it's effect or effect either. I know you're hesitating.
That's what I'm in my head, I'm like, that's the one,
I think A.
AFFEC for this.
Yes.
Yes, that's correct. All in favor?
Across Indo Valley.
That'd be fine.
Yes.
We have easement misspelled in number 3, third line of 3.
Ooh.
And I think, on number one of the conditions would be conformance with the landscaping plan, and that dated May 22nd, 2013, and that all landscaping be maintained in good condition.
Yes.
So another, and
Yeah, that's good.
That's good. Next page.
Okay.
Any further changes to the draft? Okay.
do you want to,
Yeah, we have in front of us a revised resolution. I'll entertain a motion on it.
Mr. Chairman, I move that this board approve and journalize the resolution that is set before us on the TV screen in case number 10-2013 BZA.
I'll second.
We have a motion and a second. Any further discussion? Molly, could you call that, please?
Brian Miller,
Aye.
Fred Hayes,
Aye.
Steve Haber,
Abstain?
Brian Johnson,
Aye.
Rick Oberschmidt.
Aye. Okay, case 12, Alter Crest.
Should be, in the first paragraph, grant a conditional use zoning certificate and variance.
And maybe even in the first sentence, upon an appeal and a request for a variance and conditional.
Yes.
I don't know about others, but on the fourth line there, where it talks about for the following reasons, safety grant, conditional use, for the following reasons, I'd really like to refer to that, the paragraph numbering really refers to section 357 of the, for the following reasons, can we say for the, as satisfying section, or maybe satisfying is too strong a word, or compliance with section
In
357.
compliance?
That way, the A and all those things make some sense to a historian picking this up.
It's good, good ad.
Ready?
Yes?
Steve, are you okay with the way we're doing this on the screen now?
I think it's great.
Okay, thank you.
Thank you. Fifth line up from the bottom before your, after time, space after time,
Before the V.
before the V. Thank you. Okay.
We okay to move on?
I'd add in number 3, the second part of that, the pavilion will be located so not to impact adjoining properties and is largely not visible from surrounding properties.
I'd take the word largely out, and it is not visible.
Just is not visible.
Yeah.
I think you need a closed paren at the end of 4.
That's what I was going to say.
Did I cut you off there, Brian?
Yeah, I was in the process.
Sorry,
That's all
I
right.
chucked that one up to Brian, not me.
Although the parentheses needs to be inside the, or to the left of the period. Or add another period.
Actually, no, it was correct.
That's correct.
Well, I'm staying out of that one. Staying out of that one.
That's-
Actually, you would need 2 periods.
Well, you need another
One
period.
before and one after?
Yes, you
Yeah.
need period, technically.
Good.
I'd add in, I see we did say in number 6 it's not visible, but it's okay to repeat that. But I would add somewhere in there, unless I miss it, that the front yard is so large that,
We got
is
it
it in
number
there
2.
already, number 2?
Greatly exceeding a typical front yard setback, because it's at 585 feet. per
Okay,
second.
that covers it. Thank you.
And then do we have the conditions?
Yeah.
There we go.
Didn't we have a construction start and stop?
We did. Well, you don't cut
I'm
and paste.
cheating.
Cut and paste.
I don't feel bad.
Look at that.
Is there anything else on that final page, or is that just a
the-
signature line?
The usual,
Rest of the boilerplate.
the things you can't change even if you want to.
Mr. Chairman, in the, regarding case number 12-2013 BZA 274 Sutton Road, I move that this board approve and journalize the case as amended on the TV screen.
Second.
I have a
Mr.
motion by
Johnson,
Mr. Haber, a second by Mr. Johnson. Any further discussion? Molly, could you call roll?
Brian Miller,
Aye.
Fred Hayes,
Aye.
Steve Haber,
Aye.
Brian Johnson,
Aye.
Rick Oberschmidt,
Aye.
My first vote of the night.
You are down there. Comes an hour and 15 minutes into the
Good job.
meeting, okay. Bylaws. Allison, do you want to,
Sure. Briefly, the one that was in everyone's packet this time around had, if there were any typographical corrections that anywhere from 4 or 5 of you had suggested, those were made within the text. And then there are some red lines and comments of things that were suggestions by one person or 1 or 2 people.
How do we want to do this? Do you want to put it up on the screen and we'll,
Maybe go through it page by page or something?
We can do that.
I have a version that I've mocked up,
Okay.
if you want to look at them. They're just, suggestions.
oh, here we go.
we have, oh, there we go.
That's nice.
Prepared.
Thank you.
Nothing substantive like these, mostly grammar, readability.
Okay, do we want to, why don't we pull up our first page and we can have any discussion about it? I personally would leave it as chair and vice chair and not add chairman and
I agree.
vice chairman. Be consistent with what we've done throughout.
Gender neutral.
But other than having the board shall elect is a better statement.
That's a fine statement, yes.
Great.
Good.
Those are fine changes. Other changes I think are great. You don't have to make them right now. We can,
Good.
no, I don't. I want you to be able to think about and contribute about what we're thinking about here and not have to mess with it.
A question I had on number 2, so I'm hearing we like Mr. Johnson's changes for the most part, but the question I had on number 2, or on page 2, is 1, 2, 3, about 4 paragraphs up. The presiding officer shall administer oaths. The board, through its chair, may compel the attendance of witnesses. And I always have this, I've forever had this question of, I know we put it in there, I think the ORC says even something about it, but
Oh, we
we can't, I don't think we, I mean, for practical purposes, I don't know how we can do that.
All right, so I would like to start a list of questions for Gary,
Okay.
and that would be,
Because if we can't practically do it, then,
why should we say it?
yeah.
So this board cannot subpoena?
Somebody to, well, and maybe, and if we can, it'd be nice to know that,
Right.
Maybe here's a form we use or something. I don't know.
yeah. So if we could get, that's a good point.
So our objective here tonight ought to be to get something as clean as we can, but still with some open questions, and we're not going to approve these tonight,
Correct.
I would think that's right.
okay?
All right,
So go page by page and approve whatever changes, and then discover any questions.
right.
Continuing questions we may have, okay.
There's at the top of the page 3 there, is the definition of parties and interest.
Yeah, I think that was that might have been my question, but
I had that too.
I think throughout, it seems to be used, and I'm not quite sure.
The part,
Because if this is saying that we have to give due notice of hearing to the appellant owner, parties in interest is required by law, but in point of fact, don't we give notice of the due hearing to anybody within a certain distance on it?
We do. Ohio Revised Code requires a little bit less than we do. We go a little above and beyond.
So if we want to continue to go above and beyond, we should probably say,
Define it?
define what above and beyond we're going, and then we can say, and other parties in interest is required by law. Seems to me.
Well, what is a party of interest, though?
yeah.
I think the question that you raised is outstanding, because when you raised the question, I slowed down and said, I don't have an answer to that. I don't know what it is.
And it's, there's not a clear answer to what it is. It's important for us because somebody who's found to be a party in interest has a right to appeal a decision of the board. So obviously, an applicant's a party in interest, but right after that, who else is a party of interest gets a little sketchy. So, to me, the easiest way to do it would be, we would just automatically define parties in interest to be whoever gets notice.
But this says who we have to give notice to,
Yeah, that's circular.
so it's circular.
Yeah.
But if we could define it as, we give notice to people within 200 feet of the,
Let's add property owners within 200 feet.
or equivalently, Mr. Chairman, I was thinking of adding in Article 1 a definition of terms used in this document, because parties in interest comes up several times in the document, and then just say parties in
And
interest
it
is...
may have a different, it could be different in different situations, depending on whether it's pursuant to a statute that's defining who's got an interest or not. Does the statute define who a party of interest is for notice? It does.
Yes. But off the top of my head, I have no idea.
I'm not sure it does.
In legal dictionary, thefreedictionary.com, real party in interest is the person or entity who will benefit from a lawsuit or petition, even though the plaintiff is someone else.
Yeah.
See, what might happen is we give notice to all the surrounding property owners and the plaintiff, or the applicant, I mean. And so we all kind of feel, well, maybe they're parties of interest. Well, you might have a competitor, for example, shows up and gives all these reasons why the variance shouldn't be well taken, participates, maybe cross-examines people, whatever. They may establish, for
Themselves.
appeal purposes, that they're a party of
Right.
interest.
So if you have a guy who's 201 feet away and he comes to the hearing and he gives testimony, he becomes a party in interest. That's the problem with defining it up front. It may change. I'd,
Should we delete the term then, if it's that difficult to define?
well, but I think we're saying we're going to give notice to the appellant, the owner, property owners within 200 feet. And then I don't say, and I don't have a problem with saying, and other parties in interest is required by law. Because if we're giving a notice of a second hearing, let's say that the case before us earlier had ended 2-2 and we were going to go out and rehear it, the party in interest would have been probably anybody that appeared. So unless Gary's got some further thoughts on it, I'd love to hear his thoughts on it because it'll come up again.
So the wording would be property owners within 200 feet of the subject
Right.
property.
And other parties in interest is required by law. So that way we've got in our bylaws that we are going to give notice to people within 200 feet.
Hey, this is a recurring comment I had on through all this, but I'll just bring it up now because it kind of applies. So we give notice to people within 200 feet because that's what the zoning code says, right?
Right.
One of the comments I had repeating through here is, if the zoning code says it, spells it out, or the ORC spells it out, should we really even be saying it again here? In other words, this, you say, give due notice as required by the zoning resolution and to other parties in interest as required by law. So maybe they change, maybe the zoning resolution changes someday to mirror the ORC or becomes more expansive.
Well, is the zoning code law? Didn't you just say it's required by law?
Well,
I mean, the zoning code,
Zoning code
but
is-
you have two different laws that could apply then, because you have the
Okay.
state law, which requires one standard,
right.
the zoning, which requires a greater standard in this
Mhm.
case.
Mm-hmm.
So, I don't know. Yeah, I guess.
No, you might, yeah, it makes sense to refer to the zoning code.
I don't think it's a big deal in this one, but
It may come up.
I hesitate to repeat what's in the zoning code or ORC because those change. And then you don't want to make a mistake by doing one when the other, you just don't want your documents inconsistent, that's all.
Do you think there's a problem with saying property owners within 200 feet?
No, but if that's what the zoning code says, I would just say notice to property owners is required by the zoning code. Because that's what you look to, you wouldn't look to the bylaws.
It is similar to some of the text amendments that we're proposing to the zoning resolution is language that says, you know, see this in the Ohio Revised Code because it's recently changed. So.
So the new wording here would be, give due notice of hearing of each case as required by the township zoning resolution and other parties in interest as required by law.
Yes, rather than say
I like
property
that.
owners within 200 feet, you'd say other property owners as required by the zoning code.
Other parties in interest, well,
And other
let me do
parties.
it again.
He's saying,
Give due notice of hearing of each case as required by the township zoning resolution, and other parties in interest as required by law. So we strip out the appellant, the owner, the property owners within 200 feet,
I'm okay with that.
all of those details.
Yeah,
Mhm.
I like that.
I'm okay with that. All right.
Then if you drop down to, and if I skip something, somebody just jump in that you had, but if you drop down to G, let's see, did we change it on ours? Oops, looking at Mr. Yeah, prepare summonses, just make a note on that. That goes back to the question of compelling people to come. It's saying prepare summons, but if we believe we can do that and it will stand up, then that's good. But if we don't, then that goes back to the question we just had about compelling people to be here.
See, I think that's a bracketed question for Gary again. Then I had a initial, it talks about the recording secretary, who is not, that would not be an officer, so what we're
No, that
really...
would be Betty or tonight, Molly.
Right, so is that so how do we define that a little better?
Couldn't we say the recording secretary of the township staff shall perform the following duties?
That's fine. Because I was just a little worried about how good you were at preparing minutes, Fred. and-
The actual performance is pretty bad.
Okay.
I like the way Brian is making this more modern drafting. That's very well done.
Well, I'm basically taking out the passive voice.
Right, right.
Prepositional phrases.
We want to keep some of the other changes in there, though.
Yeah, I don't have any changes that are on the new copy.
They scratched the mailed and put in delivered, and I think that's right, because we don't use the mail that much.
Right. And even if you dropped them in the mail 48 hours, you may not get them.
Where are we at, page 4?
Page 4.
Yeah, general, in that whole Article 3 cases, and I'll repeat the comment again. Let's see, it talks about what we do, appeals, grant condition, revoke, notify. Is all that basically copied from the zoning resolution?
Yep.
Okay. I would then suggest just act as authorized in the Anderson Township zoning resolution and Ohio Revised Code, something that simple.
Because
Unless there's some benefit to having it here, then I don't think there is, so if it's in the zoning.
yeah, it's kind of, and yeah, and you really don't want two potentially conflicting situations.
Yeah.
So I think one of my questions, and it's noted in a general comment later, I think, is, well, we also decide issues about, that never come before us, but the property maintenance code.
Right.
Yeah.
So, Allison, off the top of your head, if you know, I'm not sure, when we talk about Article 3 cases, how much of that going into pretty much page 4 and through page 5 and 6 is from the zoning resolution?
Most of it. B is a little more explicit within the bylaws than it is in the zoning resolution.
And there's some more specifics in there. I don't see a problem in enumerating the actions that we can do. And it's the further on details that get to be troublesome, especially if they conflict with the zoning resolution. But we can hear and decide appeals, we can act on variance requests, we can grant conditional zoning certificates, and we can revoke an authorized variance or conditional zoning certificate. And those are probably good enumerations to have in the bylaws without the details.
So as a general proposition, am I getting this right, Brian, that what you're thinking is that if it's in the code, we shouldn't restate it here?
Yes.
And if it's something we're elaborating on what is going to be required for our practice, then we should set it forth here.
Yes.
Yeah. The next draft I put together can reflect that, so.
Okay.
Great.
Okay, thanks. You know what you really need? On the next draft, when you're making changes to the zoning code, Mr. Johnson, who will get rid of the passive and generally make it far more readable.
Do you just
That
want
would
to
be
come in and
nice.
start the whole thing over?
I mean, really they're very, very good improvements.
Makes it more good English and get rid of the lawyer wording.
Hey, careful there.
Yeah, surely there's better terminology there, sorry about that. In paragraph B, a small piece, but it has a different meaning. About two-thirds of the way down there, there's a line that starts with legal and/or equitable interest in the property affected. That comma after affected shouldn't be there. It should just continue on with that sentence.
You see where that is? Okay.
You know, a funny question I have on that same paragraph is, I think that the ORC says, I always have this question, and I know we commented, we allow, and it's the right thing to do, to have everybody represented by whom they want to. Their architect, we had one last week where his friend was representing him because maybe he wasn't comfortable. Contractor, makes a lot of sense. I think the ORC says you can be represented by an attorney.
I mean, I know that's the case in the tax appeal world, but I think that's a Gary question again.
But in practicality, it's not practical.
Right. Much as
So I
much
guess-
as I am for full employment of attorneys.
Yeah, so I guess I like the addition or agent,
agent.
because that's what we do.
Yeah, so the proposed wording of attorney or agent is good.
I like that, but I just
wanna ask Terry to
hesitate
make
though,
sure-
is
make
there
sure
any
that's not-
issue if it's contrary to what the statute says?
And I guess I think one of my comments was that whole section says the procedures for a case shall be as follows. And it doesn't really get into it gets into kind of what you're submitting, but it really doesn't get into the procedures of the case. But, that's all right.
Where are we?
I was just saying that whole section starts
You
off by
said-
saying,
The
Procedures for a case.
Well, it doesn't really say
Well, it's
that.
mostly, it's the procedure for filing the case with our offices.
Well, maybe
rather than
we
the
should say that
procedure for the
then.
maybe we
meeting.
should
I
say
like
it
that.
as opposed to the procedures of conducting the case, which is what this should cover.
the filing procedures
That'd be fine.
for a case.
Good clarification. Filing.
Well, it probably is filing and conducting a case, because there are 2 or 3 sentences in here that apply to the hearing. But not much. But there it says about who can testify.
Maybe to make it more complicated, and maybe it should be separated into 2. One, here's the filing procedures, one, here's the hearing procedure. And I can't remember, is there somewhere in here where it talks about how you read the procedure at the beginning and swear everybody in and all that?
Well,
That's for sure procedure.
Right, but then what's really, I think, unusual is that we read some of our statements about we're going to limit no repetitive testimony. That's nowhere. That's not in the bylaws, is it?
No.
And that needs to be in the bylaws, it seems to
Actually,
me.
I had that as a proposed change in the order of business piece. Because that's the piece
so
that
the
actually
order-
steps through the pieces and the swearing in of all those wishing to present official testimony.
Oh, article.
I was going to add it in there.
I think it needs to go somewhere.
That order of business, that sounds like that's actually a good spot for it. Article 10. Would it be under the procedures, or any procedures we could pull out of there and stick it in order of business, call it order of business and procedures?
Mhm.
I mean, stuff that comes out of Article 3 and stick it back there.
Yeah, like the last paragraph in Article 3, for example, might be a good one.
Yeah, I
Maybe
think
the last 2, even.
the last one for sure. I think the
So-
one above it does kind of say when a case will be heard.
How to
as-
file it.
Yeah, but I think the last paragraph of Article 3 ought to go back under Article 10.
So maybe Article 10 could be called order of business and hearing procedures, something
Right,
like
and then
that.
we can incorporate some of the things from the hearing outline. There's one sentence in the hearing outline that at times I don't even read because I am so concerned about it. And if you could ask Gary about that, we've talked about it in our annual session with him. But if you could ask him about no comments or questions are be directed to the appellant. I don't know that we can have that in our bylaws in view of the right of cross-examination. If you could ask him that question.
The question there is, can people giving testimony actually offer a question? Can they speak to anybody but the board? And I thought the guidance was they cannot. Now, the board can turn to the appellant and say, can you answer that?
There's a statutory right to cross-examination in this hearing
By people giving testimony or by the board?
by, for example, counsel for the applicant. And
Okay.
and that's,
And it's
It's not-
happened
it's not
recently at
precise.
zoning commission.
Yeah.
Who
it
can,
has
who
happened at
can
the
and
zoning
can't.
commission. It has happened at the zoning commission. So you can ask Gary about that, because we read a statement that essentially says you can't do that.
Right.
Although
Probably should
you
be-
see me skipping that sentence.
Should probably be
on the
changed a
phone.
little bit, because generally speaking, when we're taking testimony and somebody gets up, we don't want them directing a question to the appellant who's sitting out there. We want it to us, and maybe we'll take that under advisement. However, there is a proper point in some hearings for cross-examination. So during cross-examination, then the person, if it's allowed by the board, could then say, okay, I'm going to present these questions on cross-examination to the appellant or witness or whomever. But yeah, it's troubling to just have that blanket statement, because then they say, okay, I'll check that box, I'm not allowed to ask them questions.
Right.
So I get
I'd
that
like-
on appeal.
And then I would instead ask Gary if he could suggest or a sentence to put in our procedures that says, in the event a party requests the right of cross-examination, the chair or presiding officer will, establish procedures to permit the cross-examination or something like that.
Yeah.
Where are we?
So I think we're back on page 6, Article 4.
I was on 8.
Is that where we're at?
You're up to
That's
8.
where I was.
I'm fine with that.
I'm fine with, on 7.
It's page 7 on Brian's, but page 6 on the other
Yep.
two.
At the end of Article 4, I would like to see us delete the fuzzy phrase of upon a determination of just cause. There's similar phrasing in Article 6 on the last paragraph, although it's more specific there. I would also be okay in just deleting that entire last paragraph to get rid of the
That's what I was
confusion.
going to say, you could delete that whole thing.
So you're saying delete the whole thing about dismissing a case for lack of prosecution?
Yes, in the paragraph on, or in the article on docket calendar.
I think we have to leave something in there, because if somebody files a case and it gets scheduled here, and we all show up and the appellant doesn't,
It's addressed in Article 6, the
Oh.
disposition of the cases. It's on page 9, or on Brian's,
yeah.
on Brian's
Oh, so
page 9.
you're saying that under that, it's got, I see your point, it's got a 1-year requirement.
Yes. Yeah, there's more specific wording there.
Then I agree, that's a good point, Fred.
So we just drop the one out of
4,
Article 4 last sentence.
assuming that we want to leave 1 year as the right time frame.
Seems like,
A
I
little
don't
long.
know. Yeah, it does seem a little long.
It does seem long.
Can we make that 6 months
Yeah.
and check with Gary and make sure it's not a statutory?
Yeah, I'd be somewhat hesitant to do so, because like, for example, the Martin Marietta case has had no activity on it for several months while we try and figure out a deadline.
It says
And
the
dates
case
will be-
may be dismissed.
Right.
Right.
That case is still quite active, though, so.
And we're the delaying party, not the,
Right, I just don't want it to come up that something like that would be dismissed when there should be activity.
I'm okay with
leaving it
6
as
months. I
may.
mean, you have to
Yeah.
exercise appropriate discretion, I think.
We're the ones who determine if it gets dismissed, right?
Right.
Right.
So,
In Article 5, I think in that case about notice of appeals, I think the parties in interest is correct. I think that's going to be, if there's a notice of each hearing, each appeal. Oh, no, that's not any different, is it?
no, it's the same thing.
You almost need to say, at the beginning of the hearing, parties of interest is everybody within whatever feet we do, 200 feet. But after the hearing, there's still the parties of interest, but there may be more.
Right.
Or during the hearing, there may be more.
But in this case, we've got now on Article 5, we've got a section on notice of hearing that may contradict the top of page 3.
It does now because they're inconsistent. But
Yeah, because
they
one
ought
of
to
them's
be-
got more language, but,
They ought to be the same.
see the point? So maybe we can figure a way to make
Some-
those
Shouldn't we
consistent,
just
Just
copy
saying.
the same words?
or get rid of them in one section or another.
Well, the Article 1 is what the Township Director of Planning and Zoning is going to do in terms of roles.
And Article 5 is the Director of Planning and Zoning shall send notice as follows.
And that's the notice of hearing. It's focused on the notice of hearing.
I think we should say something like, at the onset of the hearing, parties of interest is everybody within X feet.
And then it needs more words, though, that after the hearing proceeds, parties of interest may also include other
Interested parties.
interested parties. How's that for circular?
I wonder if we could just define it geographically at the beginning, and then it could evolve to something else, but I don't know if we can capture every potential thing in this document.
But we ought to be consistent in either,
Yeah.
maybe in the first part, we just say, give the notices of hearing as required under Article 5, or something like that, rather than trying to restate in two places the same thing.
That's very good.
Yeah, let's do that.
And then use the wording that we had here in Article 5.
Mhm. And when we're talking to Gary about the issue with the summons, I don't know if the property maintenance code is a different animal,
Sure.
where we might have to have that power. But,
That's one of the very last page, it's the only thing on the very last page, is do we need a separate section on property maintenance code appeals?
right. None of which have ever come before us. I'm on Article 6, disposition of cases.
And can I change the paragraph E, the addition on the notice of hearing, Article 5?
Your words.
We need another or another comma after readable by passersby. So the Township Director of Planning and Zoning shall post a sign clearly readable by passersby on the property subject to an appeal no less than 10 days, et cetera, et cetera. Make sense? Got it.
I had a comment on 5, too, at number sub D. Township Planning and Zoning Director shall furnish one or more newspapers, notice of the appeals, applications, and requests on the calendar of the board for publication as a news item prior to the date of the hearing. Again, I think that's something the ORC calls out. You have to publish it in the newspaper, general circulation, and they're done as want ads, really, aren't they, Allison?
There is a section for just legal ads.
Legal notices.
Legal notice.
But it's,
I
you're
would-
saying it's not a,
It's not a township-specific thing, it is Ohio Revised Code.
Yeah, I would just say shall furnish notice shall provide notice per ORC.
Well, there's some duplicative wording in section B of that same article. We ought to consolidate them into one place, too.
Yeah, that should be, I would say that should be by ORC too, because it's different, you know? If you're rezoning more than 10 parcels, then you just do publication notice. If it's a text amendment, you just do publication notice. So think about that. I would say just say, shall provide notice per the Ohio Revised Code. Okay, I'm ready for 6.
My concern in Article 6 is kind of come out on last month's meeting and this month's meeting, where it says, in the event of a tie vote, the board is required to schedule a case for rehearing at the board's expense. I'd rather take the word tie out and say, in the event of a vote that does not have a concurring vote of at least 3 members, because in the case where just the 3 of us were deciding it before,
Right.
it was a 2-to-1 vote. If it would have been a 2-to-1 vote, that wasn't a tie,
It's not sufficient, though.
but it wasn't sufficient to take the action.
Those words are in the second sentence of that first main paragraph. The concurring vote of at least 3 regular or alternate members
Right.
shall be necessary.
Right. And then we go on to say, in the event of a tie vote, but it really ought to say, in the event of a vote that does not, needs to match the sentence above it. Because to me, a tie means equal.
Mm-hmm.
Or do you think a tie means 2-to-1?
No, tie is equal. Where does it say the tie, though?
Next sentence thereafter.
In the event of
Very
a
next
tie
sentence.
vote.
Oh, okay, okay.
So it can just be a vote not meeting those
Yeah.
requirements? Okay.
Yeah.
Yeah. And then it says, schedule the case for rehearing, and maybe this is a statutory or Gary question. Does that have to be a public, I know it's a public meeting, but does it have to take new testimony? Or can it just be, for example,
Further deliberations and,
after bringing on an alternate member who has listened to the tapes? Something like that.
sure.
So if you can ask, since that, we were very close to having that very real situation today. Or I guess maybe we could have adjourned and asked Steve to go listen to tapes, something like that. Well, I mean, you know,
Yeah.
Could have.
Now, the thought on the motion to reconsider, I think once we have journalized the case, I think it's over. We can't come back the next meeting. I don't think we can come back the next meeting.
yeah, I think that's probably why I asked the question, because
Yeah.
it does say you can have a motion to reconsider at the next succeeding meeting. Well,
I wonder why you would ever do that unless you got new information, which you shouldn't have got new information, you know?
Well, let's say, I can see where you might want to do it, you know, in a certain situation. So let's say that we close the public hearing on the swimming pool case. All right, but somebody, I guess, at the next succeeding meeting could have made a motion to reopen tonight's meeting could have made a motion to reconsider the motion to close the public hearing and reopen it and ask for it to be rescheduled to get more testimony. So maybe it says, maybe it should say, or the next succeeding meeting unless the decision had already been journalized.
Okay.
So I can kind of envision a situation where it could occur.
I could see it, if there was maybe a mistake, or something was worded wrong or something and nobody caught it, I suppose.
But once we journalize something, and that is the criteria for giving that information to the appellant, it should be too late for us to
Yeah.
go back and change anything.
Right.
Yeah, because they could go forward
They could move
full
forward.
steam ahead.
Yeah.
So what would you say, just take it out then? There isn't a
No,
motion?
I thought Mr. Oberschmidt had the exact right proposed wording. Or the next succeeding meeting in any case other than a journalization motion.
But if it's not journalized, you can always change it when you journalize it, right? Because you take a straw vote, but the
Yeah,
straw
yeah,
vote's not binding.
Not binding, right. No, you can change it, so it's all, so maybe the parenthetical say, or unless the decision had been journalized at the next succeeding meeting.
Sure.
Okay.
You know, getting back to the three, I put a note down there on the tie vote. What about a 2-1 vote? So you don't have three concurring. What if you have a situation where only three can hear it?
Still requires three votes.
And that's by statute of the zoning code. It's nothing we can change in the bylaws.
Yeah, but I get that, but the way we just reworded it says if you don't get the three votes, then it goes for a rehearing.
Mhm.
For the same three?
Yeah,
Or it could
Or
be different
other-
people.
Yeah, I mean.
Well, I was
well,
just saying, I know it's a long shot, there's only three that can hear it for some
Oh,
reason.
so okay.
You only have three, the three that can't agree.
well, I mean, at some point, whether
Don't
you,
worry
whether
about
you
it.
go to the trustees and ask them to appoint another alternate member or whatever.
Okay. I had a question on the next paragraph there, no more than 5 votes, it starts. It says, alternate members of the board shall be designated either by the township trustees or by the board. I think only the trustees can designate the members, can't they?
We've never had the board designate one.
I'm not sure the ORC provides for that. Maybe ask Gary that question.
I don't think they're saying we can appoint them as much as decide which one's first and which one's second.
Alternate members shall be so
Trustees do that as well,
designated.
though.
Yeah, but they do it, yeah.
As first alternate or second. And then I had that question, you tell, Allison, is there a first alternate and second alternate, and you always call the first alternate first?
Correct.
Okay, gotcha.
The township trustees ought to make that designation, we
Yeah.
should do that.
And then a question I had is, let's see, why did I write this down here? Okay, well, you guys tell me. What if you make a motion to approve and it fails? Is that a denial? Is that a no action? You have to form a new motion, the case is over?
We'd have to form a new motion or rehear it.
Yeah, the
So it's
motion-
not a denial then?
Right.
It's just a failed motion? Okay.
What's that again?
If, let's say, somebody made a motion to approve, to grant the variance, and the vote was 3-2 against that motion, does that in and of itself act as a denial?
No,
And
we're
the
saying
answer
it
is,
doesn't.
it does
Doesn't.
not. There would have to be then another motion made to
To deny
deny.
it. So that every, okay,
Everything requires an affirmative vote.
right.
I don't know if that's just worth saying or not, or is that obvious?
It's
If
in
a mo-
our,
if-
I think, our hearing outline that we have Rick read, it's that affirmative motions are encouraged.
Well, in one case, you haven't passed the variance. Then does that not suffice for denying it?
It would just be a failed motion. Somebody would then have to make a motion to deny the variance
Failed
request.
motion. That's interesting, because when I was on Marymount, we made every motion in the affirmative, so each person knew how they were voting.
in the affirmative, in that it was approved,
Every motion was made to approve.
I've seen that.
and then they're always denied.
And then
They're voted down.
they're voted down.
Yeah, that's always, I've seen that too, that's confusing to me, but I've seen
Well, it's-
places do that.
Well, it was really clear for us, but I think in light of the failed motion versus denial is really impactful.
Right,
Yeah.
it makes a difference, huh?
All we did was not pass it. We didn't say no. Yeah, I probably got to go back to Marymount here.
Get re-indoctrinated.
Exactly.
Okay.
Where did you say that was included, though? I was just looking through the bylaws, Allison, and
It's not within them.
it's not with...
No, that's what we were talking about with incorporating the hearing outline
Hearing outline.
It's
That
in
we
the
typically-
hearing outline.
to Rick.
The friendly
Do you
chairman.
read that part of it?
Chairman, no, I don't read all of this stuff.
Okay.
before I
Might
give it-
might be worth having in there, I don't know. If a motion fails and you have to form, it's a no action, you have to form a new motion.
Just as a separate paragraph?
Yeah. I said see also page 9, why did I say that?
That's the official action. Required majority of 3 affirmative votes for adoption.
Right, less than that denial. Okay, less than that, yeah, deny. If you don't have 3 affirmative votes, is that a denial? Do you reform the motion?
Well, see, final disposition must be a resolution which grants or denies the appeal. So you've got to adopt a resolution that either grants it or denies it.
Where does it say that?
Article 6A.
Yeah, that implies that a failed motion is nothing more than a failed motion.
Right.
Okay.
So we don't need anything more.
I don't think so.
I'm okay with it.
So where are we at, Mr. Chair?
I think Mr. Johnson's comments are all improvements on the language. I don't know if others have substantive issues. I mean, we talked in general about Article 9, Article 10, rather, the need to incorporate.
Yeah, I've got some more there, but the very end of Article 6, the highlighted question about provided by law needs clarification. What do we want to do with that?
I think that's probably okay.
Okay, I was going to say, if we go ahead and create one definition for parties of interest.
Well, this one just really says it's the notice of dismissal given to the appellant in the manner provided by law. I guess the clarification is, does the law clearly tell you how to do that?
Okay.
Or do we need to set forth in the bylaws that how it's done?
That was my comment. I said, I don't think there is a manner set out anywhere, so it's just,
I think that's a question as to whether there is.
maybe we should just take it out. Notices on such dismissals shall be given to the appellant.
Period. In whatever way we do it is okay.
Yeah.
I like
Well,
that.
unless there's a law that requires
Unless-
us to do it in a different way.
Yeah,
Well, if there is, then
that's maybe a Gary question. I don't think
Yeah.
there is, so.
You don't think there is?
Then are we down to Article 9? Sorry, Article 10.
Mm-hmm.
And the Article 10 is now Order of Business and Hearing Procedures
Yes.
is the title.
Well, I had one quick, are we on 10? I had one quick thing on 9, because sometimes it's confusing to people, I think. It says on 9, all records that shall be kept in the file of the office of the board in such a manner available inspection. Well, we don't really have an office. The office of the planning and zoning, I added, the office of the planning and zoning director shall serve as the BZA office. Maybe that's unnecessary, but sometimes I think we have visitors here and they actually think this board has some presence here in the building other than, you know, on
Day of
meeting
month.
nights.
Okay. One thing that I was really going to get to on the order of business, reading of minutes of the previous meeting.
It's been in there.
You know, this is already dull television. The only thing that would make this duller television is if we had to
read the
read
minutes.
the minutes of the previous meeting. So unless there's some statute that requires us to do that,
I would say take it out.
Well, we do need to approve the minutes.
right. I
Okay.
just don't think we need to read them. Or if there's some statute that says we do, then we need to waive that requirement each time.
I had just a comment on E on that hearing of appeals. We refer to kind of everything generically as an appeal, and I just wondered if we should, because there is an appeal this board hears, which is administrative appeals. They're unusual. We might have had a few in the past few years. But what we really hear is administrative appeals, variances, conditional use.
Yeah, so rather than use the word appeals, it's really hearing of
Cases.
Yeah.
Tonight, we did the roll call approval of the agenda, and we went right into the hearing of the cases. And we did the minutes afterwards, and allowed the public to leave more quickly. I didn't think of it ahead of time, but I think that was probably a nice move. We probably ought to move our administrative stuff to the end and let the public move on, even though it's still a public meeting.
What I'm hesitant about with that is that if we do not approve minutes, like tonight, we had a case continued. If we don't approve the minutes of that case when it was heard previously, should we really continue the case?
Yeah, so let's leave it where it is, and like today, we bounced it behind the line, it didn't have an impact.
Right.
But I see the point. So we're, on the swimming pool case, before we got back into that case, we approved the minutes of the meeting to have it. I don't think that's a requirement, because there have been
No.
times when we've fallen behind in approving minutes. But I don't have a problem with leaving it up at the front. It's not a big,
Do we need to add an exception? Because it says the order shall be as follows. We need a,
as opposed to, and unless determined otherwise by
Right.
the
by the board.
board.
Yeah.
Good idea, thank you.
You ready to move to 11?
No, I was going to.
Go ahead.
I was going to hit the swearing in of witnesses and the procedural kind of thing. That's where I was proposing that we swear in all those wishing to present official testimony, not just witnesses, because the appellant is a person that needs to be sworn in too.
Rather than the word witnesses, you brought a word. And then I guess, in reality, we do that before we do other things.
But I think that's a good spot for it. Yeah, I think this is fine.
Well, but what we follow here, we do it before we approve the agenda and read the minutes, I think, in the script. Where's the script?
Yeah, it's one of the first things you do.
Yeah, on the script, so either we had changed the script or changed this.
Yes, you'd outline procedures first and then go into the agenda and minutes and then cases.
But the swearing in occurs before we go into the agenda and everything else. So swearing in D really, either we have to change the script or it goes as between A and B. When do we do the roll call? On that script? That's before.
Before
Yeah.
you swear in, yeah.
So the second thing we do, first thing we do is roll call, second thing is swearing in.
I'd change the script. How, where's the script come from? Is it a synopsis of what our bylaws is?
Just
Or does it
procedure.
come, or does it come from someplace else?
No, it's just procedure.
Yeah, this, right before you open the public meeting, I think is a good spot to go ahead and do the swearing in.
Yeah, because people are still kind of
Coming
coming
in.
in sometimes.
Yeah,
I'm okay with it.
You just need to change the script then.
yeah.
So next meeting,
So-
gotta kick me.
So the script needs to be basically consistent
Or-
with all this.
Right. And then should we have an item?
Well, perhaps the agenda. I mean, I know, Rick, that you talk about how the BZA was formed and
Right.
whatnot, but doesn't it make sense that the agenda be written out such that we'll do approval of agenda, approval of minutes,
Swearing in.
swearing in
Yeah.
of those that are testifying, and it would reflect this order of business right here.
And I really wonder, should there be something that is like a call to order and review of procedures? I mean, that's what we in fact do.
Right.
And we don't have it written down anywhere except the script.
Right.
It probably ought to be in here.
That's what they're going to incorporate some of that.
As we're talking about the script, should there be an article added in here that says, this script shall be read before every, or is it?
That's what I was going to say, the call to order and review of procedures.
Okay,
Where the,
we'd set out the script there.
well, I don't know, if we have the procedures generally here, then the review of the procedures would be really reading the script.
Okay.
But yeah, I had written down some thoughts, and I'd take it off of the script, but it was the kind of words that you normally say, that all testimony should be given to the board, that this is an input, this is not a forum to sway public opinion. It's a review by this board of the case in front of it. You also talk about a 4-minute limit of any testimony, no repetitive testimony. We ought to just put that script right in here.
Yeah, that's what we talked
Oh,
about.
okay, okay, good.
Do we have a 4-minute limit?
Yeah.
Right.
I often skip it if it's
I
not
didn't.
going to be a crowded meeting.
I've heard you say that.
If there's a big crowd, you'll hear me
Yep,
say it.
sounds good.
Tonight, I didn't feel the need to move the Boy Scouts to 4 minutes each.
4 minutes.
The only other item on this article was item I, unfinished business, was called new business. Unfinished business is probably old business.
I think it was intended to be both.
Oh, old and new,
Yeah, so maybe,
scratch new, or
Or-
scratch business. Yes. Unfinished business. Then I'm done with 10,
So no new business is brought to the board?
unfinished.
you can put new business as a separate category, I guess.
Yeah,
Right.
unfinished
So it-
business and then new business, I
Right.
guess, yeah.
Right.
And we just call it old business? That's what everybody calls it.
Instead of unfinished, old
Yeah.
business, yeah.
I like unfinished.
You like unfinished?
Unfinished. Doesn't matter though.
I can go either way. Now, here we have another party in interest.
Yeah,
I think this one's fine.
I just said see prior. I guess all these parties and interests all have to
They should probably be
be
the
the
same.
same, yeah.
Well, but I think, yeah,
And that may be where we benefit from just having one definition in the beginning.
okay.
The question I had for this is, I've never heard of this before, filing this with the recorder's office. Would the recorder accept?
They would
For
accept it if it
filing.
had a legal description, a few other things.
Yeah,
I mean, it's kind of
They
like the
would.
judicial decisions, they get filed all the time.
We file all
With the recorder's
zoning
office,
commission
Zoning
decisions with the
decisions get
recorder's
filed.
office, and they're
Do
just
you?
filed with the
you just have to
site
have them in the
plan.
right format or whatever.
The,
So that kind of puts it on in the chain of title or something?
Right.
I can see the case of the swimming pool, the guy across the street filing for that continued maintenance of the vegetative screen becoming part of the property record there.
I mean, I think it's a fine idea, I just didn't know if
There's seldom is there going to
recorder would
be,
accept it.
there's seldom going to be a situation where recording one of our decisions makes a difference in anything. But there might have been, I can recall one or two cases where there was kind of a requirement that something happened on another piece of property. And, it was kind of so if so-and-so agreed to provide access or provide an easement, that would be where you would want to record it.
Yep.
And then in 12, let's see here if we have it marked. Or if Brian's.
We've got just a few minutes left on the tape. If we want to put in another one, we can break, or,
That's fine.
We're going to go with well, we're done with all the rest of the motions though, right?
Yeah, this is the last thing.
Last time? We can do this.
We'll give her a second to sub it in.
Ready?
Set?
I was just going to say in number 12, every appellant file, it kind of goes back to hearing of appeals or variances where I think it should say something like every applicant filing a request with the board shall pay, et cetera. Every applicant filing a request with the board.
Okay. Good point. I have a question on the code of conduct
yeah, that was something we wanted to ask Gary.
about attempted.
What qualifies, is a hello at the grocery store enough? Or
Yeah,
is it,
because we get situations where somebody will call me on the phone and say, and I say, I'm sorry, I can't discuss this case, and they say, fine, thank you, and they hang up.
right,
I don't, or you pass somebody at the grocery store, what about that case? Sorry, can't talk to you about it. And it's certainly, I don't, feel that it needs to be disclosed
no, I think
to
if
the
it ends at that point, it
Right.
probably would not need to be
Right. As
disclosed.
opposed to as opposed to attempt, if any discussion occurred,
Right,
then notify the board or the chair of the board. But the mere attempt seems to be too much.
What are you changing now? I'm not following.
Where it says, when personal contact has been attempted, it should be reported to other members of the board. So and I've had members of the board at least inform me of situations like that. So if somebody walks by you at the grocery store and says, hey, how about that case you're hearing? And you say, sorry, I can't talk about it, and they say, oh, sorry, does that mean, the way this is written, you needed to come to the entire board and say, or to the board and say, oh, I was at Kroger's and Joe tried to talk to me about the case and I said no, and he said, fine. I mean, that's just kind of, that's a little much. But I think we do need Gary's input on that. As opposed to,
Actually transpired.
right, actually transpired. Or somebody sends me an email and says, I'd like to talk to you about this case, and I reply, can't.
Yeah.
That happened too.
So you're saying we just have to follow that, but just because you told somebody I can't talk to it, you don't,
Have to report that to the whole board.
Now, did we, the highlighted section there on the procedures in the meetings, we've handled that one, right?
Correct.
How
And then on the
about
last-
final one, though?
could we back up real quick? I'm sorry. Before the code of conduct, the last paragraph on the prior one, I guess it's 12. Any communication purported to be an appeal, and I circled appeal, but failing to meet the requirements. And I said, an appeal, I guess that goes back to the other point, an appeal of an administrative decision or all, quote, appeals that we're using generically for everything. Somebody sends you a letter out, says, this is my conditional, I want this, here's a letter, I want it to be a variance or whatever. I mean, it says we can that will be disregarded probably at the staff level if it
Right.
doesn't meet these rules and regulations. Do these rules and regulations actually, I know we talked about, but does it actually specify what precisely must be in an application? Because I don't think.
It does.
It does,
And
okay.
then we have, typically, they come into us and we work with an applicant discussing those items, the 10 copies that must be submitted, a letter identifying X, Y, and Z. Those are all within the bylaws.
These are within, so I would just suggest maybe any communication purported to be an application.
Yeah, it's that broader word again.
Okay.
And then I'll also ask Gary about how to handle the property maintenance appeals.
If any of them were to come. Okay. Any old business?
That was all.
Any unfinished business?
That was unfinished. It still is.
Any new business? What else am I supposed to ask about here? Any
Ongoing.
administrative
Ongoing.
matters?
Well, new business, I'm sorry, Mr. Chairman, we still need to help us and Allison get a date for the Martin Marietta, even though you may not be personally involved, interested, nor,
If you were not able to bring something with you, go ahead and email me any travel dates that are unavailable in June.
what are the date windows that you want to,
I want any and all this month. I want to know where you are, I want to know when you sleep,
because we're going to do this,
because we're going to get this done this month.
okay?
So you want available evenings in June?
Yes.
Evenings, not Saturdays.
I really don't want to come in on Saturday.
Saturday evenings.
Mr. Haber doesn't want to either. I saw that in email.
You will all owe me so much coffee if I come in on Saturday.
Do you want to do that now, or you want to do it in email?
Go ahead and email it to me.
Okay.
So I'll sit down with everyone's and find, even if this room is not available, I'll find a room here.
It does need to be a public
It needs to be a
meeting.
public hearing, but it doesn't have to be in this room.
Okay.
Anything further?
Nothing
If not, we can adjourn.